Everybody, have Bobby Buchanan here today to talk to us about how the divorce laws in Illinois compare and contrast with the divorce laws in Utah. Thought this would be a good thing to do for people thinking about whether or not to get divorced in Utah or in Illinois, or just kind of know how they compare and contrast. And Bobby's an attorney out there. You've been doing this for how long now, Bobby, out in Chicago?
It would be about seven years, going on 8 years, that I've been doing divorce and custody work in Chicago. So thanks for having me. And yeah, this should be fun.
Great. So you represent mostly men or all men?
I would say about 80% of my caseload is men. I certainly don't say no to women when they ask me to represent them, and obviously zealously advocate for whoever my client is. I've just kind of found a niche representing men because of my own personal history and kind of passion in doing this. And I found that I naturally connect with fathers as I'm representing them. So, I've kind of just followed my passion in my branding and my marketing a bit.
Cool. Okay.
Yeah.
Good stuff. All right. Well, let's start this out. So talk to me about how Illinois thinks about debt and asset division. What are the kind of normal rules there for debt and asset division in a divorce?
Yeah, absolutely. So in Illinois, it's an equitable division state, or equitable property division state. So what the court does is puts the property or the debts into two different baskets, if you will, to start the analysis. You're going to have your non-marital property and then your marital property. So marital property is anything acquired after the marriage, and non-marital is anything before. There's definitely exceptions. For example, inheritance or gifts are the big exceptions for marital property. So if you're inherited something and you never mix it with marital property, it'll stay generally non-marital. So once you have those two baskets, then you divide those. So you'll take your non-marital property, and then the marital property is going to be split. And the court says it's going to be split equitably. 97% of the time, that's a 50-50 split. Pretty straightforward. There's certainly, outliers there, but that's how it works on the property side. Do you guys, and I haven't looked much into Utah law at all in kind of anticipation of this. So if I ask you questions, it's truly out of curiosity and somewhat of naivete. But are you guys a community property state or equitable division?
That's a good question. So we're equitable division.
Okay.
So it's almost the exact same analysis that you laid out is kind of what we do. So the community property states are those southern states up into California and Washington. I think Nevada is a community property state, if I'm not mistaken, but Utah is an equitable division of assets and debts. So we do almost the exact same thing, almost always 50-50, probably, 90, 95% of the time it's going to be a 50-50. You have to show some extraordinary circumstance to get it away from 50-50. I mean, somebody's committing fraud,
right?
Or there's just such a disparity that the judge is going to say, no, that's not equitable. But that just doesn't happen very often.
Right. I mean, I'd imagine you get clients who talk to you about, well, the other side didn't contribute anything, and so they shouldn't get, a 50-50 split. And I think the case law in Illinois is basically like you just being at home and kind of maintaining the marital presence at home is enough. Like, that's your contribution. Like you said, it's got to be pretty extreme not to go 50-50 for the equitable split.
Yeah, it's almost the exact same thing. I mean, here we have a lot of traditional families. So men work and they're breadwinners, and women stay home and have like 4, 5, 6 kids.
Right.
And I get a lot of guys coming in here and they say, well, she didn't really do anything. She just stayed home with the kids. I'm like, oh, dude.
Yeah.
You never stayed at home with your kids before? It's like,
yeah.
If you did it, you'd kill them. So no, that's not going to work. Yeah, I have to have that conversation all the time with people.
Yeah. And like we were talking about before we kind of started recording here, I have a young one. You have a couple of kids too. And my wife is working 24/7, so
Yep.
that's I completely get why the law is the way it is. It's hard to give up, half of your retirement if you're in a a long divorce. It's certainly really not what your financial plan was, but that's the way it goes. Just kind of the bullet you have to bite.
Exactly. And it wasn't her financial plan either, right?
Right. Right.
Exactly. And in fact, so that brings, we might as well just talk about retirement. So let me kind of tell you how we do retirement here in Utah. You have defined benefits, and you have a 401k or a pension. I'm sorry, let's do pensions. So you have a pension or 401k, essentially. Those are the two major retirement drivers or vehicles. And if you have a pension, we have an equation for that. And it's essentially half of the accrual in the pension during the period of the marriage. So that's our general rule. The rule with the 401k is essentially the same thing, slightly different language because it's not a pension, but it's the same deal. It's half of the accrual during the time of the marriage. So somebody's married for 20 years and they've worked a job for 40 years, you get half of the 20 and not half of the 40. So that's kind of how we do it. Is that pretty similar to how you guys do it?
Yeah, pretty similar. So the way that you guys do it, does it say straight you get half, or is it this is how we calculate it and you get an equitable portion, which turns out to be half? Just to be.
So on that one, we don't say equitable portion. Everything's always equitable, but we just the case law lays out an actual calculation.
Yeah.
In there. And so you just run the calculation, but that's how it works out, is you just get half of the accrual during the period of the marriage.
Yeah, it's generally the same here. So we have a case that is kind of the seminal case. It's called the Hunt case. So we call it the Hunt formula. And you're basically taking, and I don't want to butcher this, but you're taking the number of years you've been contributing into the pension. And that's one of the parts of the fraction. And then the other part of the fraction is how long you've been married. And by kind of inputting that, you're saying, okay, that's the proportion that is marital, and then you're dividing that. So it works out basically the same thing. I mean, what the court is basically saying is, here's how we're figuring out what is marital of this pension, which isn't necessarily, definable depending on what kind of pension it is.
Okay. Yeah. So they're pretty close to the same. Okay. Yeah. And if there's in Utah, if there's a black letter law, it's this, that you are not getting around giving up half of your retirement if you get divorced. It's just almost never going to happen. And it's almost never, I think in maybe one or two cases in my career, I've seen it different than 50-50, where a judge just said, no, it's different. But you're always going to give up at least half of that during the accrual period.
Do judges allow you to contract around that? I mean, do they find it unconscionable if you do? Like, do you do kind of offsets against equity and property and that sort of stuff? Or is it pretty straight line, you have to divide this pension?
We can always negotiate around it. They don't have any problem with that. That's one of the very nice things about Utah is the judges will let you negotiate kind of however you want in your divorce. They never find it unconscionable pretty much.
Yeah.
And sometimes we do that, and then it becomes a little tricky because you have the present value of money compared to the future value of money in a 401k. But we have ways of figuring that out mathematically. But yeah, sometimes somebody will just take all of the house equity, right? And then somebody will take all of the 401k in the future.
Yeah. Similar here. At times we have to get like just an actuarial involved to say, okay, this is the value. And it's just kind of a general figure to start negotiating with. But yeah, sounds similar, very similar.
Yeah. And they'll allow you to do that, right? They don't have a problem with you negotiating around things.
No. As long as as long as one party is getting, as long as it's not completely unfair, you can do it. Yeah.
So even here, if it's completely unfair, they're not going
to look into it. It's interesting. It depends too on the judge. I mean, here in Cook County, I don't know what it is. We have like 35, 40 judges just a block and a half away from here that do divorces. There are judges that have reputations of really diving deep into the documents when you do the final prove up, as we call it. Other judges don't at all. I mean, obviously that stuff can come back on what would be a motion to vacate or something like that, where one party has buyer's remorse, they hire a lawyer, and then they file a motion saying this is an unconscionable agreement. At that point, it's going to be revisited. Some judges try to catch that stuff on the front end and saying, no, we're not going to do this. Other judges don't. So we try to be a little selective if we have something that we think is on the gray area as far as picking the judge that we know will get the case through.
That's interesting. So we don't really have that. The only time the judges will reject a stipulation or an agreement that we have is sometimes people will try to get around child support, which is a no, you can't do that because it's the child's money and not your money.
Yeah.
So they don't let you negotiate around that, but that's probably 90% of it.
Yeah.
So what we have to do, if you don't like your agreement, you have to file a motion to set aside the stipulation, is what we call it. And those are almost universally dismissed. They just do not. Once you sign that stipulation, you are in, and they will not mess with that.
Yeah, I would agree here too. It's almost impossible to do. If you enter into an agreement and it got by the judge the first time, to undo it is going to be very tough. It certainly happens. I mean, I have colleagues who've done it, but once you sign off on that and then the judge signs off, it's pretty much a done deal.
Yeah, the only time I've ever really gotten around it, so there's case law that says even if it's fraud, there's non-disclosure, you're not really getting around that, because you could have gone to trial, but you chose not to.
Right.
Especially if there are attorneys involved. The times that I've been able to get around the stipulation and get it tossed out is if there are mental health problems. So somebody was bipolar at the time, or suicidal or something like that. We can almost always get it tossed out at that point. But for the most part, you sign the stipulation and mediation, you're finished, and it's just paperwork after that.
Yeah, exactly.
Cool. Okay. So we talked about debt and assets. Talk to me about custody. This is kind of your deal. How does custody work out over there?
Yeah. So in Illinois, we call it allocation of parental responsibilities in court. Nobody calls it that out of court. I mean, when I'm talking to clients and even my colleagues, we still call it custody. Mm-hmm. And there's two aspects of it. There's parenting time, and then there's decision making. And so kind of those are the two big prongs that you have to decide on or agree on when you're finalizing a divorce. The parenting time, that's, your typical schedule. And then that's going to be broken down into your school break schedule and your holiday schedule. And then decision making is the four major areas is going to be education, extracurricular activities, religion, and medical decisions. The way that most divorces happen as far as getting that allocation of parental responsibilities agreement done is they're sent to mediation. So you file a case, your first court date, you'll let the judge know that there's children involved, and unless miraculously you already have that agreement done, the judge is going to send you to mediation, which is, I don't know, I think it's a 2-day process, probably like six hours total. And I'd say about 50% of cases get resolved through mediation.
Are those private mediators, or those mediators that the court provides you?
Those are in Cook County. It's court. It's part of the court system, so you don't have to pay anything. I think there's a $50 co-parenting class that you have to take as part of the mediation process, but that's it. And it's actually a very effective way of settling cases and getting them through the system. There are other counties I practice in where it is private, and it's $200 to $300 an hour that people are paying to resolve their case. How about?
That's our system. We have if you're indigent, essentially, you can go in and have like $25 an hour mediation. But our policy here is we don't use those mediators because
Yeah.
they're not good. So we just do private mediation all the time.
Yeah.
And it's between, and there's some very good ones at $150 price point, but most of the time it's between $200 and $300. And the mediations will last about 4 to 6 hours.
Okay.
So when we do it, we have about an 80% success rate if you're getting divorced and you have kids. So we go in for one session of mediation. About 80% of the time, we're going to get it done. But we're not doing mediation until we have the financial data together and all these other things. And that's usually about 2 to 3 months into the process.
Okay.
So we're really ramping up and then getting into that private mediator. But it sounds like you guys just do it straight off the bat.
Yeah, we do it straight off the bat. It does take about 3 to 4 months because it is Cook County and everybody's going through it. So it takes 3 to 4 months. So if you have an issue before that, we're generally filing a motion to set a temporary parenting schedule or something like that. Half of the time, the judges will punt it. And if they hear and it feels like something where like, you don't really need me to figure this out, they'll say, just figure it out in mediation, and they won't enter an order on it.
Really?
If you articulate to the judge why it's so urgent and that the lack of any sort of court-ordered schedule is affecting the children negatively, then they'll set a hearing on it. But again, every judge is kind of different in that realm as far as how they treat that. So when you're doing your cases, typically speaking, is that something that you're having to address in the beginning? Are you filing motions to resolve a parenting time schedule?
About 15% of the time we do that in our cases.
Yeah.
So that we call them temporary orders.
Uh-huh.
So we're filing and going to temporary orders about 15% of the time. And that's usually because either the people are stealing kids from each other.
Yeah.
Right. And we need to get that figured out. Or the husband will cut the wife off all the money. So we need to get in and get temporary alimony and child support. And then we also figure out possession of the home. But it's interesting that your judges can punt because ours can't. So if we have a different system out here. We have commissioners that are kind of like under judges, but they just do family law cases. So the commissioners have to make decisions on all of these cases that come before them. So if we file for and go to a hearing on temp orders, then they have to make all those decisions, and then they tell us to go to mediation after that.
So what are your timelines like? Because I think Cook County is kind of infamously slow on certain things. So typically we'll file a motion. We'll do what's called, you guys, I'm sure, call it the same thing, or maybe you don't, but presentment, which is we present the motion, say, Judge, here's the motion we've filed. And then we ask for a hearing date. Depending on how the judge is feeling about the case, they could either say, okay, we're going to set a hearing. This is expedited. I'm giving you a hearing in 2 weeks. That's pretty rare. Most of the time it's like, okay, well, we'll set a status date, meaning you'll come back in 30 to 45 days to let me know whether or not you were able to agree on a resolution. And so you'll come back in 30 to 45 days and you say, no, Judge, we need a hearing. And then they'll look in their book and they'll say, oh, I don't have anything for about 60 to 90 days. And then you'll get a hearing about 60 to 90 days. So there's kind of this pressure to just figure it out on your own because the court system is overwhelmed, basically.
Yeah, it's so backed up. Yeah, see, the way we do it, we'll file for a motion and it goes before the commissioner, and that usually takes about 6 weeks. So sometimes 2 months. But usually right around that 6-week mark. In some of the smaller counties, so I'm talking Salt Lake County, in some of the smaller counties around Salt Lake, you can get in 3 to 4 weeks. But here in Salt Lake, it's like 6, and then you just get in. They don't, like I said, they don't punt it. You just go in and you do your thing.
So if you don't like what the commissioner said, what's your option?
You object to it, and you can go up to a judge. And then you get a de novo or a completely new hearing where the judge listens to the whole thing. But here's the thing. It says de novo on paper, but I was just having this conversation with an attorney in the office the other day. What you really have to do is tell the judge why the commissioner was completely wrong.
Right.
because the judge doesn't care about family law cases. They just don't. They have commissioners because they don't want to hear family law cases.
Oh,
So
okay.
if unless the commissioner is completely wrong and you can show it, the judge is just going to go along with the commissioner. So we don't object very often
Yeah.
unless it's a pretty clear cut mistake, because
Yeah.
we know that we're just going to waste our clients' money doing it.
Yeah. I'd imagine in areas of custody, it's hard to show a mistake.
Yeah, exactly. In custody and parent time, it's almost impossible. It's almost always money stuff that we
Yeah.
object to. I mean, sometimes in custody, it's so egregious that we will, but that's, once a year maybe.
Yeah. Cool.
Yeah. Yeah. Interesting system. So do you have family law judges, or are they just normal judges who do family law cases?
For all family law. So it used to actually be split. So we would have paternity judges and then divorce judges. So we had judges that would only do custody cases, unmarried parents, and then divorce judges. That changed. They consolidated the division a couple of years ago. So now every single judge, they just handle domestic relations stuff, but they handle the gamut. There is somewhat of they divided up between pre-decree and post-decree judges for certain judges. It's a very convoluted system that we don't really, even as attorneys, understand why they do it the way they do it. Some judges are called individual calendar judges, where they'll handle cases from beginning to judgment. After judgment, they'll keep the whole case. Other judges, it's part of a team system where you have kind of a judge that's ahead of the team. He handles all the pre-decree stuff and then assigns it out for trial. And then you have a different trial judge. And then after trial, you get a post-decree judge. That's personally, I think that's the most problematic. It's hard to settle cases when you're doing pretrial conferences with the judge who's not going to actually hear the case.
Exactly.
So they're giving these recommendations, and then you advise your client, you're like, yeah, that's his recommendation, but this is kind of a gray area thing. So we could go to trial and possibly get something different to happen. So
that is crazy. I've never heard of a system like that in family law.
Yeah. I don't know. I've only been, I've been doing this for, going on 8 years or so, but it's all I've known. And there's certainly inefficiencies with it, to say the least.
That's insane. So we don't do that at all. So we have the commissioners.
Yeah.
They, like I said, act as under judges. So they do everything except the trial. The judges do the trial, but we have one judge that sits over the case, and then the case stays with that judge. So if there's a modification at some point in the future, that judge and that commissioner that were on the case in the beginning are going to continue to be on that case.
Yeah, that makes a lot more sense. We do that for like half of the judges do that. But then for some reason, there's this whole other half where there's like these 4 teams of judges, and it gets moved around, and it becomes problematic because you have these long custody cases where maybe the case has been in the system for 3, 5, 7 years. And if one judge knows it, they can make really informed decisions. Whereas you get a new judge and you're having to educate them on all the nuances of the case, and it can be difficult.
Wow.
Yeah.
Oh, that's super interesting. Okay. So tell me how judges there in Illinois think about 50-50 custody.
So there is no presumption here that 50-50 is in the best interest of the child. So that's, the standard that I think probably every state uses to decide custody questions is the best interest of the child, which is obviously a very vague, open standard. Judges look at everything. But there is no presumption that 50-50 is the in the best interest. Usually, I think it's starting to shift a bit, and your best chance of getting 50-50 is making sure that logistically it works. So, when I'm representing dads who have been, maybe their role has been minimized and they're trying to get back to getting 50-50, I tell them, do everything that you can to make sure that you're living in the same school district as the child, that your work is conveniently located, that you're able to participate on a regular basis in some of that day-to-day stuff. But if you go in thinking you're just, hey, 50-50 is going to be handed to you, you're going to be sorely mistaken.
Okay.
Yeah.
So it's not like Arizona or California where they have a real they have a real specific presumption for 50-50.
Yeah, definitely not. I know it's been proposed here as far as changing the law, and it might happen. I wouldn't be surprised if it happens in the next 5 or 10 years, but right now, definitely not what the law is. Pretty standard here is to get, if you're the dad, as it goes most of the times, to get every other weekend and maybe a weeknight as well. You could maybe push that to a long every other weekend, like a Thursday through Monday or something. And then on the off week, you have Wednesday night, overnight, or maybe just a dinner or something. But that's a little bit more typical if you're going to see more time.
Okay.
Yeah.
Okay.
How about you? You guys don't have a presumption of 50-50.
No, we don't. So it's interesting. The statutes on the books, we have a few of them. Up until a few years ago, probably 3 to 4 years ago, it was kind of minimum parent time was the standard, and that was every other weekend and one night a week.
Okay.
For like 3 hours, right, on a Wednesday or something like that. And then it changed. So now the presumption is much more of a 40-60 split. So if your dad, you 40% and mom would get 60%. And what that looks like is like Thursday overnight every week, and then a long weekend until Monday morning every other weekend. Right.
Okay.
Kind of what you were describing, but we just set that out, and that comes up to 40-60 split. So that's much more common now. 50-50 is becoming more common, but it's still a fight. When I get guys in here, they'll ask me about 50-50, and I say, yeah, let's ask for it. It's hard to get, and we're swimming upstream to do it.
Yeah.
When moms come in, we have some men's rights law firms here, and they always ask for 50-50, no matter what. Like he hasn't seen the kid for 5 years, and they'll ask for 50-50. Right. So I have to tell him, okay, no, that's not where we are. It may be here, but we're definitely going to negotiate down. This is just kind of what they do, because this is how they sell to the men.
And I'm guessing for the guys, is it partly a financial question? I mean, is it how does the child support work for you guys? Does the overnights part of that?
Yeah, so overnights are part of this, and I was going to ask you about this because you had a video not too long ago on Facebook about this. So what we do is, if it's 0 overnights to 30% of the overnights in a year, so 109.5 or 110, then it's the exact, you pay the exact same child support. Okay. 0 nights to the 30%.
Right.
Then once it gets past that 30% mark, then we look at the number of overnights, and it can change. So every overnight, your child support is going to go down if you're the one paying. Right? Yeah. And the way we do it is weird, because they have a calculator, and we put numbers in the calculator, and it spits out some magic number, but they never tell us what the equation is. So you just have to figure it out by doing like 10,000 or 50,000 of these over the years. Yeah. So what happens is, once you go from 110 up, then it's like $1 a day for a while, or $2 a day. And then it hits some magical point about 125 or 130 overnights. And then it really starts dropping off. And once you get to 50-50, it really drops off the amount that you pay in child support. So, say somebody makes $100,000 a year and the other person makes $20,000 a year. Even at that point, and you have one kid, you're maybe paying $300-400 a month of child support, even though there's this humongous disparity. You make all sorts of cash. Yeah.
So if you're 50-50, is it just basically taking into consideration who makes more? I mean, or is there one parent who's like, okay, this is the primary parent and it's always going to go to them?
Yeah. So the person who has more overnights is almost always going to receive some sort of child support. right? So the way our calculator works, it's gross monthly incomes of both of the parents, and we shove that into a calculator, and it's the number of overnights that are shared between the two parents, and those are the only variables.
Yeah.
Really. I mean, there are a couple other variables, but they almost make absolutely no difference. So it's almost always just those two, and we shove it into the calculator, and it gives us a number, and that's what it is.
Yeah. Pretty similar here. 146 overnights is the magic number. So if you have,
so like a 40-60 split.
Yeah. So if you have anything less than 146, it doesn't matter if you have one overnight or 145 overnights, you're going to be paying the same thing. Once you hit 146, then it really starts to take into account what, how many overnights there are. And yeah, I've shot a couple videos on this, and I know I did the calculations. I forget exactly offhand what they were, but it was something I put in there that both parents make $6,000 gross per month. And the difference over the course of 18 years, if you have 145 overnights versus 146, was like $180,000, which is insane to me. Like it's literally 18 days less you have, and it's costing you six figures, which I hope the law changes. I don't understand why we can't just take into account the overnights, but just make it kind of a scale that just goes up like this based on, one overnight, plug it in, two, and you go all the way. I'm not a mathematician or an economist, but it seems to be more common sense and fair to do it that way. I'd imagine you guys get into fights over those thresholds as well. I mean, there's always the elephant in the room when you're talking about parenting time, whether or not you're doing more or less than the 146. Whereas if it was a gradient, I don't think we would be fighting over it as much.
Yeah, we always fight over the 111 number. So it's funny because everybody thinks the number is 111 because that's what the calculator has in it, but the calculator has the wrong number. When the bureaucrats set it up, they didn't read the statute well. So it's actually 109.5, but it's 110 really, but we say 111. So we're always fighting about the 111 number. So our thing is, we, like you, have different types of custody. There's physical custody, and that's where your kid is physically and where your kid stays overnight. And then there's legal custody, and that's who gets to make big decisions for your kids: religion, medical, extracurriculars, schooling, stuff like that.
Mm-hmm.
So when we get to 110, 111 overnights, then we get into joint physical custody. Mm-hmm. There's not too much of a difference. The major difference, though, is if you're in joint legal or joint physical custody, it's harder for the other parent to move away.
Okay.
So if you have like the minimum, which gives you, I think, somewhere in the neighborhood of 50 to 60 overnights a year, then your ex can just move with the kid and go to New York or Florida or Chicago or wherever she wants, or wherever he wants.
They don't even need to ask permission?
No, they just need to give notice, and they can
But go. You can't even object.
Oh, you can object, but if you have that low a number of overnights a year, the court's going to say, well, we already have this other law in place that you're going to get essentially the same number of overnights a year, so we're going to let them move.
Gotcha.
Right? You're just going to get them at a different time. You're going to get more time during the summer and more time during the holidays, but it's going to come out to the same numbers, so they're just going to be able to move away. But once you get to about 111, 110, 111, you get that joint, then it becomes much more difficult for them to move away. So that's always a point of contention, and that's something we negotiate about.
Gotcha.
But it's almost never a money thing. Like, it makes so little difference between 110 and 109 and 111. No one cares.
Right. It's more just how much power or control you have from them moving away.
Yeah, exactly.
Our law for what we call it relocation, it doesn't speak to overnights. It just talks about mileage. So I think if you're living in Cook County, it's 25 miles. Some of the more of the collar or the other counties, it's 50 miles. And it just basically says if the majority parent's going to move further than that amount, they have to give notice. If it's objected to, they can file a petition for relocation. Practically speaking, though, I'd imagine if you have the vast majority of the time, judges are going to lean towards letting you move. If it's for something like a better career opportunity or better schooling for the kids, those big things like that.
Yeah, exactly. See, ours is 150 miles.
Okay.
So
Oh, wow.
I know it's a long way. So you can literally have 1/3, 2/3 split, and
Yeah.
then they can just kind of, or 29% or something, and they could just, up and leave and go to St. George, which is, a couple hundred miles from here, and or Cedar City, somewhere around in there, and be okay. But once you get past 150, that's the magic marker for us. So it gets into these weird situations where they'll move 100 miles away, but they share essentially 70-30 time.
Right.
And then you get these kids back and forth in the car all the time. It's crazy.
So do people file motions to modify the schedule? Can you modify the schedule based on that and say, like, listen, these kids shouldn't be in the car for 4 or 5 hours every couple of days or whatever it is?
Yeah, you can. Judges don't really do too much about it, because the only way to deal with it effectively is just to change custody.
Uh-huh.
And to do that, you have to petition to modify the divorce decree, and then you have to go through the rigmarole of actually, doing the whole thing and changing the entire custody, which usually will involve a custody evaluator, so an expert. So,
Yeah.
doing it for that purpose doesn't usually work, and it takes way too much time and costs way too much money. So people just deal with it.
Yeah.
I'd kind of like to see the radius kind of zoned in a little more than 150 miles, but they're not going to change that law anytime soon.
Interesting. I feel like in Cook County, it may be easier to change parenting time than a lot of other places. Like, the law basically says once a custody agreement is entered as a final judgment, you can change parenting time as long as it's necessary to align with the best interests of the child. As if the circumstance,
Wow.
yeah. So it's not a substantial change of circumstances that you need. You just need any change in circumstances, and you can go back and say, we need to modify this. Whether a judge will agree or not is a whole other question, but you'll get put back in the pipeline. They'll send you back to mediation. They'll possibly appoint a guardian ad litem or something like that to facilitate figuring out what's in the best interest of the child, and you might be able to modify it.
Okay. See, our modification is a little bit different in the sense that we have a threshold question. So the threshold question is substantial change in circumstance that was unforeseen at the time of the signing of the decree of divorce, right? So there's got to be a big change that you didn't really anticipate. And then you have to get over that threshold. Then you go to the best interest standard for the child. So we have a lot of fights about whether or not something is a substantial change before we ever get to, is it in the kid's best interest? But that's for a change in custody.
Yeah.
So that's going from, primary physical custody to joint physical custody. If it's a change in parent time, so you're not changing the custody, 110 to 111 or something like that, then it's just pretty much any change and in the best interest of the kid, which kind of tracks what you were talking about. But if we change custody, then it's a higher standard.
Yeah, we don't have any of those thresholds, like within, like, if you have more or less than this, then we're calling it something different, really. It's all parenting time. And that's really, there is a custodian for the purposes of school enrollment and any other statute that might require a custodian, but how it moves within, whether it's you have one overnight or 180 overnights, it's still just parenting time. So
okay, that's super interesting then. Okay, cool. I want to be sensitive to your time, so you tell me when you have to take off here.
Yeah, I think about 5 minutes.
Okay. Well, let's talk about alimony for a second. How do you guys do alimony? Well, let's do this. So let's talk about child support. How long do you have to pay child support, or until what age?
So you have to pay child support until the child graduates high school or 18. It's usually graduating high school, because most people turn 18 when they're in high school. So If they turn 18, they've graduated high school, then you're done. And if they haven't graduated, then you're waiting till they've graduated. So that's when it terminates. Are you guys the same?
It's the same. It's the exact same thing. I was wondering if Illinois, if you guys were like New York. So I think New York you pay until they're like 21 or some such thing.
Oh wow, no, but we do have college contribution, which is
okay. So we don't have that.
Yeah, which is kind of crazy. I'm not really a fan of that one. And one judge recently did rule it unconstitutional right before he retired, and then he was overturned by the appellate court.
Nice.
But if your kids go to college, you can petition the court and say that the other parent should contribute. And judges, kind of the most common ruling in those cases or recommendation is a third, so that the child's taking a third in debt, and then the parents are splitting the rest of it. But those are pretty common cases. I mean, I've done more than a handful of those as well, which is kind of another form of child support.
Wow. Yeah, that's interesting. We have nothing like that. Once they're 18, there's done. So most kids will go to college out here. A lot of them will go on religious missions, Mormon missions.
Right.
And people try to talk about that and contribute to that because it costs about $10,000. And judges like, nope, absolutely not. They're 18. They can pay for it themselves.
Yeah.
Okay. So quick, how do you guys handle alimony out there?
Yeah. So alimony, or maintenance is what it's called in the statute, but certainly alimony in common terms it's a threshold question of whether or not you're going to have to pay it. And there's no formula for deciding whether or not you have to pay it. There's just a number of factors, the incomes of the parties, the lifestyle of the parties. And then I think there's like probably 6 or 7 more, the distribution of property. Once the judge has decided that maintenance is appropriate, then you go into a formula. And it recently changed. I think it changed right when the federal tax code changed, so that maintenance was no longer a deduction, I think is now where we're at. So now I believe it's 33% of your net income minus 25% of the net income of the person you're going to be paying. So your spouse is what you have to pay. So if we were to do the math, you're making $100,000 net. So that's $33,000 minus, we got to do math in our head now. Let's say that they're making, what's easy, $40,000. A quarter of that is $10,000. So $23,000 a year is what you'd be paying. And then the duration is based on the duration of the marriage. So it's broken down into each year has a factor. So if you're married for 20 years, you'll be paying at about 100% of the duration. I think 20 years is a threshold where they say, you could be paying for the rest if we decide the rest of your lives. If you're married for 10 years, I think the factor is like 0.7. So you multiply the duration of the marriage times 0.7, and you'll be paying for 7 years or something like that.
Okay.
Yeah. Yours?
That's interesting. So ours is, it's not formulaic like that. There is no actual formula. Yours is like super specific compared to what we have.
Yeah.
So ours is capped. The length of the time you pay is capped to the number of years that you're married, unless there's a disability of some sort. Right. So, but 99.9% of the time is just capped to the length of marriage. And we try to negotiate that down to about half of the length of the marriage. So if you're married for 20, you're probably going to pay somewhere in the neighborhood of 8 to 12 years, somewhere in there. And then what we do is they're called the Jones factors. If you don't have any need of alimony, then you don't get any alimony at all. So if you have 2 people, one makes 120,000, the other makes 80,000, the one that makes 80,000 is not going to get any alimony, because you just don't really need it.
Yeah.
So we look at lifestyle and how much people are spending per month as a family. That's the standard of living. And then we look at the the spouse who makes the least amount of money and see what their income is in comparison with the standard of living. And if they need money to get up to that standard of living, then that's their alimony ask, right? And then we go to the other side and we do the same calculation and we see if they have surplus money. And if they have surplus money and there's a need for alimony, then that's the alimony that's paid, the kind of confluence of those two numbers.
Interesting. That seems like when you litigate those sorts of issues, does it become pretty contentious? I mean, it seems like you could get kind of lost in the weeds quite a bit if you're kind of looking at that sort of stuff.
Yeah, because the other things, well, kids, people fight about two things in divorce. They fight about kids and money. So you're going to fight about your kids because they're the most important thing in the world. But when it comes to the money part, pretty much everything is laid out with the exception of alimony. So on the money side, we almost always fight about alimony and pretty much only alimony. Then we have a fight over the kids.
Yeah. Cool.
Yeah. Awesome. All right. Well, I want to let you go. It's been fantastic, man. I thank you for taking the time. I learned a ton.
Yeah.
I think it was great.
Yeah. Marco, thank you so much. It's been a blast. And obviously let's do it again if we have any sort of developments or reasons to. And yeah, super fun.
That'd be awesome. Thanks, Bobby.
All right. You got it.
Okay. Bye.
Bye.